On March 16th, FinCEN announced the creation of the Kleptocracy Asset Recovery Program. This program is aimed at offering rewards to people who provide information to the US government about various stolen assets that are linked to the Russian government. It can implicate people who work at financial institutions, as well as a number of other types of companies that are involved in high-value transactions, such as transactions involving real estate, artwork, luxury goods, or crypto assets. Today, I'm going to talk about how this program works, some opportunities that it creates, as well as some potential challenges. The Kleptocracy Asset Recovery Program is managed by the US Treasury Department. It offers rewards of up to $5 million for information that leads to the repatriation, seizure, forfeiture, or restraint of certain types of stolen assets. It's primarily focused on stolen assets that are tied to the Russian government or certain Russian oligarchs, but it also can apply to other categories of stolen assets, including assets tied to the 1MDB Malaysian fund or assets that are tied to Odebrecht, the Brazilian construction company. The rewards program creates two major categories of opportunity. The first is to assist in the prevention of crime. A lot of companies have been looking for opportunities to help resist the corrupt acts by the Russian government, and this program is aimed at doing exactly that. Second of all, you can get a financial reward. Congress has authorized rewards of up to $5 million, and in some cases they can be even higher. Now, there's no guarantee of getting a reward if you provide information, but generally, FinCEN is very interested in motivating people to provide this kind of information, and so they're likely to recommend a significant reward if you give information that results in the forfeiture or repatriation of stolen assets. The challenges that the Kleptocracy Rewards Program can create for companies are similar to the challenges that are created by whistleblower rewards programs. Companies should keep in mind that even if they determine that a transaction doesn't involve a stolen asset, one of their employees may disagree. And it's entirely possible that an employee will directly file information with FinCEN and seek the $5 million reward. Once that information has been provided to FinCEN, whether it's by the company or by an employee, it's likely to result in additional scrutiny. That can be scrutiny from OFAC of completely unrelated transactions. It can be investigations by the Department of Justice. And if you're a regulated entity, you're likely to get inquiries from your regulator. It's also important to keep in mind that OFAC has taken the position that it can impose a civil penalty on a US person that engages in a transaction with a sanctioned entity on a strict liability basis. That means that even if a US person doesn't know that they're engaging in a transaction with a sanctioned entity, OFAC can still impose a civil fine on that US person, which includes companies. So the questions of what the implications are of filing a report with FinCEN as part of an application of a kleptocracy rewards application can be complicated, but good news, I'm a lawyer. So if you have any questions either about the Kleptocracy Rewards Program or sanctions programs generally, give me a call. I'd be happy to talk to you.